Don't forget, you can reach the latest episode of Potomac Watch anytime. Just ask your smart speaker, play the Opinion Potomac Watch podcast.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. Let's turn to a second case that came down on Thursday. This is Starbucks versus McKinney. And notable, Alicia, another unanimous result. There's a concurring and dissenting in part opinion by Justice Ketanji Brown Jackson, but concurring in the judgment. So all 9 justices agreed on the outcome. It's a remarkable amount of unanimity from the Supreme Court this late into June. But can you give us an overview of what the Supreme Court did here?
So what happened in this case was Starbucks fired some employees who were trying to unionize, and they came into this Tennessee store, basically trespass, broke in when they weren't supposed to be there, and then held some kind of interviews with the press. Starbucks then fired them for violating company rules. The union organizers filed a complaint with the National Labor Relations Board, whose regional director investigated and then filed charges of unfair labor practices against Starbucks. This kind of set off the administrative process in which the NLRB then just investigates, considers the facts, and there's back and forth. But during this time, the regional director is also allowed to, while the administrative process proceeds, to file a complaint and seek an injunction in federal court, which is what she did in this case. And what she sought was to have the employees reinstated with back pay and among other things. Now, Starbucks challenged the Sixth Circuit's standard for granting injunctions, which is much more deferential than the standard in most other circuits. And again, there has been a split in the circuits, but the one reason actually that the NLRB prefers to bring cases in the Sixth Circuit versus the others is because of this deferential standard in terms of granting injunctions. So under the Supreme Court's traditional test for granting preliminary injunctions to order a party to do something or not to do something, a party must demonstrate that he is likely to succeed on the merits, likely to suffer irreparable harm in the absence of relief, and that the balance of equities tips in his favor, and the injunction is in the public interest. So that you have to satisfy all 4 parts. It's a much higher standard than the one that the Sixth Circuit has imposed for the last 4 decades. And again, it has imposed this standard only for the NLRB. And this standard only requires that the board show reasonable cause that an unfair labor practice has occurred and that injunctive relief is, quote unquote, just and proper. This provides a lot of discretion to the judges, and they are supposed to basically defer to the NLRB on the facts and the law. So Starbucks challenged this and went up to the High Court, and Justice Clarence Thomas, writing for the unanimous majority, basically held that the Sixth Circuit standard substantially lowered the bar for securing a preliminary injunction by requiring courts to defer to the board's own view of the facts, law, and equities. Thus, the result of the ruling is that the Sixth Circuit must apply the same 4-part standard as all the other courts and as applies to all the other federal agencies. Again, this is kind of an abstruse case, and the details, you can get kind of bogged down in the legalese. But it was important for uniformity, but also protecting employer rights.
Finally, on Friday, the Supreme Court issued an opinion in Garland v. Cargill. This is a case over whether the Bureau of Alcohol, Tobacco, and Firearms has the authority to ban bump stocks by defining them or redefining them, as the case may be, as machine guns. This is a 6-3 opinion on ideological lines, the majority written by Justice Clarence Thomas. Kim, can you remind us what is a bump stock and what did you make of this ruling?
Bump stocks are accessories you can get for your rifle that essentially use the motion and recoil of a firearm to allow a person to fire their semi-automatic firearm more rapidly than they would otherwise. And what happened here is that we have a prohibition against automatic weapons in this country. The ATF under the Trump administration decided to classify a bump stock as something that effectively turned a firearm into an automatic weapon. This was what the lawsuit was about. And Clarence Thomas, in what I thought was a very clear and straightforward decision, went to the statute, actually very outright defines an automatic weapon, which is, and I will quote, any weapon which is designed to shoot or can be readily restored to shoot without manual reloading by a single function of the trigger. And that essentially was what Clarence Thomas went through, single function of the trigger. And he continued to point out that if you have a semi-automatic weapon, it cannot fire more than one shot by a single function of the trigger. Moreover, it cannot do so automatically. The user actually has to be exerting some force, forward pressure on the rifle's front grip. And so the point being here that this is just what the text says. And, I think it's really great. My favorite part, a very short concurrence by Justice Alito, who said, by the way, this doesn't say anything about whether or not we shouldn't ban as a policy matter bump stocks. There's a very simple remedy to this, as everybody wants this to happen. Congress should amend the law, but you don't get to go back and dig back into a very old law and reinterpret the way that the very clear language of the law reads.
Let me underline that point, because I agree that as a matter of statutory interpretation, this is pretty clear on what the definition of a machine gun is. And to my eye, the dissent by Justice Sonia Sotomayor is at its best when it's raising examples of edge cases that are driven by the ingenuity of America's firearms tinkerers. Apparently something called a forced reset trigger that pushes the trigger forward against the shooter's finger after the initial pull. Or what about this? An owner of a semi-automatic rifle had placed a fishing reel inside the weapon's trigger guard. When he pulled the switch behind the original trigger, the switch supplied power to a motor connected to a fishing reel. The motor caused the reel to rotate, and the rotation manipulated the curved lever, causing it to fire in rapid succession. And so those are things that the ATF, as an example, has classified in the past as machine guns. But what makes this different to me is that, according to Justice Clarence Thomas, there were 10 different times in the past that the ATF has said that these bump stocks were not machine guns, did not automatically fire multiple rounds by the single function of a trigger. And I don't think the ATF gets to change that opinion and thereby require Americans who have these devices to turn them over or become felons and face prosecution basically on a whim. And Alicia, I would second the recommendation of this short concurrence by Justice Samuel Alito, because the subtext here is that when the administrative state is allowed to change the law, then Congress doesn't have to do its job. What caused the ATF to change its view of bump stocks was the use of bump stock in a mass shooting in Las Vegas. But the fact of that lamentable and tragic shooting does not change the fact that it's up to Congress to decide what activities by Americans, what gun accessories are legal or not legal. And if Congress gets in the habit of just passing that stuff off to the administrative state, then nobody who's elected ever has to take a hard vote, because whenever the bill to ban bump stocks or not comes up, they will just say, we'll leave it up to the ATF. And that is part, I think, of the dysfunction that we're seeing now in Washington. And Alicia, we'll give you the last word.
I think that's right. And as you mentioned, or you're bringing this up just as we're waiting for the decision on the Loper case to come down, and that challenges the Chevron deference, in which courts are required to defer to the administrative agencies on their own interpretations of the law when it is supposedly ambiguous. Many cases, obviously, it isn't. But this was actually a strong argument that the plaintiffs in that case made, is that Paul Clement, representing them in the oral arguments, made, is that when judges genuflect to regulators and regulators take in their own hands to rewrite the law, that really results in Congress not doing the hard work and Congress abdicating its own responsibility to actually write the law, write it clearly. And I think we're increasingly seeing that in Congress. They're not passing laws. There's a lot of talk about regulating stable coins, regulating AI, but Congress actually actually isn't passing laws to do that. And instead of Democrats, for one, right now are punting to the Biden administrative agencies. And don't be surprised if Republicans were to do the same if Trump were to win election in November.
Thank you, Alicia and Kim. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back next week with another edition of Potomac Watch.